also references the TMDL for this section of the James River. There's a total maximum daily load that's been developed that deals with the bacterial impairment. So the bill will make sure that we get all of this stuff done to the point that it will eliminate the bacterial impairment from the river. So does that mean that every discharge is going to be eliminated? No. Does it mean that the health hazard and the environmental hazard are going to be eliminated in time? Yes.
Thank you, Secretary.
Mr. Chairman, I guess the second question, and I'd be interested in hearing your thoughts on that as well, is with respect to funding. Because I know that the Commonwealth has already provided funding for Richmond and for Lynchburg, and so the whole reason we're providing Alexandria funding is from an equity standpoint. And so I guess I'm a little concerned that we'd be putting more money into Richmond, and what does that mean then for Lynchburg and Alexandria?
Mr. Chairman, Deliapova. So, with my understanding, please someone correct me if I'm wrong, is that if the General Assembly carries forward what's in the House and Senate budget this year for Alexandria, they will have fairly significantly exceeded what the city of Richmond has gotten from the Commonwealth. No, we're not there. Equal. Okay. So, which is good. Alexandria has a problem to fix. Richmond has a much bigger problem to fix in terms of volume. So I don't necessarily think that we'll be taking away from the efforts that Alexandria is undertaking. But we would be trying to set up a situation where we are showing the need to the General Assembly and hoping that the General Assembly will provide some assistance to the city.
Thank you, Mr. Secretary. Any more questions from the
And Mr. Chairman, I might add, this affects all of us. I mean, it affects everybody in the Commonwealth, really, that uses the Chesapeake Bay, because if you think about it, Hampton Roads is like a septic tank. And I shouldn't say that in front of Delegate Bloxham, but everything that we discharge up here all flows down to the lower bay, and it really has a hard time getting out at that point. So this affects so many citizens. I do believe we need to make this a partnership of sorts. I certainly believe the city needs to bear some burden in this. I'm just not sure they're able to bear all of the burden in it. So I do believe the Commonwealth needs to be a partner in this. At the end of the day, I just want this fixed and stop dumping all this sewage into the river. And I think we're going to have to work together to accomplish that.
Mr. Chairman, and I agree with you, and I'm totally going to vote for this. I just want to make sure that, again, getting back to that equity after Alexandria, I want to make sure that Richmond's doing what it needs to do. I want to make sure that Lynchburg is doing what it needs to do. And at the end of the day, unlike what my understanding with the original consent agreement was, that we're actually solving the problem and we're not allowing millions or billions of gallons to continue to be discharged to the James River.
All right. Any more questions from the committee? Seeing none, anyone from the public wishing to speak in favor of the bill?
Hello. I'm Calvin Farr, representing the City of Richmond. I'm the Director of Public Utilities. Just so I got a prepared statement. I want to thank the Senator and Governor's Office on working with the city to get to this legislation that is before you today. As I said from our very first meeting, Senator Stewart, my goal of the city is no different than his or anyone else's, which is to eliminate combined sewer overflows as quickly as we can and to help improve the water quality in the James River. So I'm an engineer, and I want you to know that if we're simple engineering, we would have accomplished this by now. But it's not simple, it's very complex. Essentially, we are re-engineering a system that we've inherited and has developed over a century ago. I want you to know that we've made progress. In 2015, the General Assembly appropriated $45 million for our efforts. Today, we're capturing almost 92% of our CSO volumes. So we're in compliance with the regulatory instruments that control and regulate our operations. Additionally, we report annually to DEQ regarding our efforts. So last year, James River received the most prestigious award for rivers, the 2019 International River Foundation's East International River Prize. It was noted in that award that James River has transformed into one of the most improved rivers in the country. The city had a major role in that from providing recreational access to making steady environmental improvements. The last bit of progress could be challenging and expensive. Before the 2020 General Assembly began, we were already moving down the pathway to review in detail our existing long-term control plan and began developing engineering alternatives and solutions to continue to make steady improvements. This is one of the reasons we agreed to collectively work on the legislation with the Senator and the Governor's office. This legislation recognizes a pathway, but also recognizes that our solutions could be expensive. And more importantly, it also recognizes the challenge we have in our city, including that approximately 25% of our population is at poverty level. So I just wanted to take the time to make sure that you hear the City of Richmond is in agreement with this legislation, and thank those folks who helped work through this. And I'll take any questions you have. I think we are using the money that we're appropriated for. We estimated originally $415 million left to spend, but the challenge is the rate impact to our ratepayers. And that's a real situation here in the city.
Thank you. We're gonna try to put 4 or 5 minutes on the board. We have several bills and several folks need to be in different committees. So if there's anyone else speaking in favor of the legislation?
Yep.
James River?
James River. So just want to say that we appreciate Senator Stewart for bringing this conversation forward, for bringing all the stakeholders to the table to talk us through and make sure that as we accelerate the timeline for addressing Richmond CSO, we do it in a way that's workable for the city and for its residents. JRA has been following this issue for a long time. We do test the water every summer so that residents can make an informed decision about bacteria levels before they go out and enjoy the James. But the James is making improvements, and it's with the help of Richmond. So we certainly appreciate this, and we look forward to continuing to work with DEQ, with the governor, with Richmond, and with the General Assembly in the future to make sure that we have the funding to make this happen.
Got it. Thank you. Anyone else?
Mr. Chairman, Peggy Sander, Chesapeake Bay Foundation. Like the James River Association, we support the bill. We support the bill recognizing that the city has, in the last several years in particular, undertaken some extraordinary steps related to improving water quality. This, to us, appears to be a next step that's really very important. We join with the city in asking you all and your colleagues to continue supporting this effort as we go forward with financial appropriations as may be necessary. It's an important step, and it deserves all of our support. Thank you.
Thank you. Anyone else from the public in favor of the legislation?
Just quickly, again, Matt Strickler with the Governor's Office. We appreciate Director Farr and the City of Richmond's agreement to work with us on this. Certainly appreciate Senator Stewart's leadership and support of this compromise bill.
Okay. Anyone speaking in opposition to the bill? I always think you're going to speak in opposition when I realize you're not. Delegate.
All of them. Mr. Chairman, I have a motion. Move that we report the substitute.
Second.
All right. We have a motion, properly motioned, properly seconded. Let us know how you feel on the electronic voting board. All right. Vote 8-0. Thank you, Senator Stewart.
Mr. Chairman, members of the committee, thank you.
Going back to the original, reservable. Senator Searle, you have SB 106.
Right. Thank you, Mr. Chairman. Senate Bill 106 is a bill that bans fracking in the Potomac Aquifer. The Potomac Aquifer is basically everything that's east of Interstate 95. There was about 84,000 acres of land that was under lease for fracking about 4 or 5 years ago. A lot of localities have already banned fracking in that area. Not all of them, but some have. I know Delegate Ranson's very familiar with the situation. But the Potomac Aquifer is a source of drinking water for probably about between 2 and 4 million people. And the last thing we need is a bunch of fracking chemicals in there. So that's what the bill does. It's just limited to that area. And I'm happy to answer any questions anybody has about it.
Any questions to the committee? Delegate Bloxham.
Thank you.
I'm sorry, Eastern Shore is covered too.
And my question, are there any leases left in this area?
It's hard to know. That question's been asked a couple times. It's hard to know exactly whether the answer to that, but the answer, I think Senator Stewart told me that he thought there were still a few, but most have expired. but it is known that there is the Taylorsville Basin is a shale that's underneath the area that could be used. It's not quite as big or potentially lucrative as the Marcellus shale, but it's still there.
Mr. Chairman.
Delegate San Francisco.
But in the midst of all of this, the question that I have always asked the administration or the agencies, has anyone even inquired about fracking in our region? Has there even been an environmental impact assessment done?
Mr. Paler,
It's a question.
DQ.
Yeah, Mr. Chairman, Delegate Ranson, I don't believe there has been any impact statement done. That would be triggered with an application. I don't believe we've gotten any applications, but there certainly have been leases that sort of triggered the whole discussion about how we're going to handle this. And we did develop an MOA with DMME to deal with it, but nothing has really started anything moving.
Thank you.
Any other questions from the committee? All right, so hearing none. Anyone from the community wanting to speak in favor of this legislation? All right.
Mr. Chairman, Pat Kellogg, Virginia Conservation District, we support this bill and appreciate the senator for bringing it.
Thank you, sir.
Gustavo Angeles from the Sierra Club, Virginia chapter, we support it.
Thank you, sir.
Mr. Chairman, members of the committee, Jay Ford, Chesapeake Bay Foundation, we support this legislation.
Thank you,
Mr.
sir.
Chairman, Bern Hussinger, Friends of the Rappahannock, and we support this bill, and we thank the senator for bringing it.
Thank you.
Mr. Chair, Grace McGuire from the League of Conservation Voters, and we support the bill.
Thank you. Anyone else? Anyone speaking in opposition to the bill?
Mr. Chairman, members of the committee, David Clark representing the Virginia Oil and Gas Association. I'm not actually here to oppose the bill, but I do think it's important for the committee to know that fracking can and is being done safely. We understand that this part of the Commonwealth is a sensitive area. In fact, there already are statutes on the books that add protections for anybody that wanted to go in and drill in that area. We don't think the bill is necessary, but we're not opposing it because it is limited to this sensitive area of the Commonwealth. Thank you.
A question for the individual. What makes this area more sensitive than any other area of Virginia?
Well, because of, as already has been, Mr. Chairman, what's already been mentioned is the Taylorsville Basin is a large aquifer serving, I think, basically from Virginia Beach up to a large portion of the eastern part of the state. There's already been a lot of drilling into the aquifer, but not for fracking. And if there were fracking done in that area, it would not be done in the aquifer. It would be done thousands of feet below the aquifer. We believe it could be done safely, but we understand the sensitivity and the concern about doing that any kind of activity in that part of the state.
Yeah, Mr. Chairman, and I think the big difference is in the geology, right? So it's the crystalline rocks where if something does go wrong, your problems are going to be more localized, whereas in the coastal you got the sedimentary where that groundwater is going to move much quicker back and forth and have the potential to impact drinking water wells.
Delegate Blocks.
Maybe the witness can answer this. So if I have a lease, would this be considered yanking the rug out from under my feet? Or not? There are some leases still in Taylor Basin, what he's saying. So I'm just curious how that works in terms of the law.
Mr. Chairman, this question came up when I carried the bill 2 years ago, and at least the jurisprudence of the U.S. Supreme Court is that for something to constitute a taking, it has to be a 100% complete devaluation of your property, and where the government only takes away one stick out of the bundle and not all the sticks, it doesn't constitute a taking. And I can cite some more specific cases if you really want to get into that discussion, but okay. But yeah, so the answer is no. And Mr. Chairman, I do have I forgot I had a line amendment to make really quick, just a clarifying amendment.
Sure.
Council has it.
Mr. Meacham?
Mr. Chairman, on line 14, halfway through the line, you'll see the phrase, prior to January 1, 2020. This amendment strikes the phrase there and moves it up one line to the spot right after the word regulation.
Yeah, Yes, we're just making clear that we're talking about a groundwater area designated before January 1, 2020, and not a well drilled before January 1, 2020. It was a little bit ambiguous the way it was stuck in there, so we just wanted to clarify that.
Do we have a motion on the amendment?
Move the amendment.
Second.
All right, all those in favor of the amendment, say aye.
Aye.
All right, amendment's before us. Delegate Helmer.
Mr. Chair, move to report.
Second.
All right, we have a motion properly moved and seconded. All those in favor, please vote in the electronic voting board.
No bills. What am I doing here? Oh, I guess that. Fracking business.
All right, by a vote of 7-0.
Sorry.
Senator Serval has another bill passed.
Great.
All right.
Thank you. I got it in
Except for
there.
one, sorry.
All right.
Thank you, Mr. Serval. All right, next on our list is, Senator Reeves. Actually, hold on, Senator Reeves. Senator Peterson, do you have a chair, you have to chair a committee right now, don't you?
I don't, but this is pretty quick, I think.
Senator Reeves, are you all right with that? Senator Reeves.
I'm sorry.
You're okay with that? All right, Senator Peterson.
This is this is Senate Bill 843, Mr. Chair. This is an administration bill. It's about 3 paragraphs. It deals with sediment, stormwater and sediment control plans, which would be submitted to the State Water Control Board and reviewed by DEQ. And it just has a standard that would apply when you have a de minimis land disturbing activity. And this is, Matt would know this better than I would, right, Matt?
Sure, well,
There you go.
Director Paler probably knows better than I would.
Okay, or David Paler, but just basically says that the State Water Control Board can establish a risk-based approach for a de minimis land disturbance. So I know I'm in Delegate Bulliver's bailiwick here, but
Is that Mr. Senator?
that's the
All right, do we have any questions for the committee? All right,
What is that,
what does that mean?
Chairman?
What does de minimis mean in this
Well,
case?
De
In
minimis-
my neck of the woods, what does that mean, Mr.
Well,
Chairman?
it's a legal term which basically means, I would say marginal, or not even marginal, basically mathematically insignificant. It would be,
Acres?
yeah, I mean, de minimis, I think, David, you would know better than I would.
I mean, de minimis, it means small and inconsequential.
Inconsequential.
It's essentially a way to go ahead and manage these plans, given the limited staff that DEQ has.
Right.
And Director Paler can probably do a much better job of describing what that de minimis impact would be. with
Director Paler,
respect to
can you
this.
give us the definition of what the de
Is
minimis
it
means?
finally that driveway that I wanna build?
Mr. Chairman, this bill contemplates the development of a regulation before it goes into effect. And de minimis would take into account the acreage of disturbed land, the distance from a surface water, and the amount of disturbance. And so there'd be a long discussion about that. The idea is simply to be able to move quickly on approval of those plans that have very little chance to cause a problem. If a problem, this does not absolve them if a problem is caused, but it helps us to move quickly and efficiently with the ones that are limited risk.
That's
All
awesome.
right, thank you, Mr. Paler. Delegate Bloxham.
I guess, just for the committee, the way I read this, David, is that, are we starting like a certified planner can do this? Can do this small plan, can be written and get a check off? The way I kinda read it, is that like a B&P certified nutrient planner? Is that what we're trying to set up here or not?
Yeah.
That's what it looks like. I mean,
Right.
Mr. Senator, Peterson, is that
I
right?
would defer to my learning colleague,
Ah.
because this is what he does.
Well, I'll
You'll defer to
Mr. Chairman, I don't wanna speak for Director Paler, so.
Mr. Chair, Delegate Bloxman, you can correct me if I'm wrong. No, it's not about nutrient planning, it's erosion and sediment control planning.
No, but, I'm
And-
sorry, Mr. Chairman, what I was saying was it's like the nutrient management planners can get a plan certified, and it looks like to me that we're setting up a certified plan reviewer, or that can do this for you, and you just check off on the engineering plan. Is that kind of the way I'm reading it? Or is that-
Mr. Chairman, that would be right. And this only affects those plans that are in opt-out localities where DEQ does the work for them. Any county that has opted in, they can continue operating the way they do.
Thank you, Director Paler. Any other questions from the committee?
Yes.
audience wishing to speak in favor of the legislation? Administration.
Yeah, Matt Strickler, Secretary of Natural Resources, Governor's Office supports the bill.
Thank you, Senator Strickler. Anyone else in the community? Anyone wishing to speak in opposition to the bill? All right, with that, the committee works on motion. Moved and seconded. We have a motion properly seconded. All those in favor, please vote on the electronic voting board. All right. By a vote of 8-0.
Thank you,
Senator Peterson.
gentlemen.
Thank you very much.
Thank you, appreciate it. Yep.
All right, Senator Reeves, I apologize about that.
You're all right.
You have a guest, Senator Morrissey.
Well, Mr. Chairman, Senator Morris is my chief co-creator. I know it's an unusual pairing, but. Mr. Chairman, we have Senate Bill 769.
Yes, sir.
And really, 769 does about 5 things. It brings transparency, stability, and accountability to the DEQ decision-making process for folks that are going through that process. It allows all the parties to know the actual basis of a DEQ decision when Mr. Taylor makes that decision, creates an actual court, a record for the court to review the director's decision, requires the actual evidence to be cited when decisions are made that directly affect many of the localities. And those localities are here today, Mr. Chairman. It requires the director to take into account all the localities affected by the actions, not just the host location. I have Attorney General Troy here to speak to the matter as well, and I'd like him to be heard as well as some of the localities. But that's what the bill does, and I would yield to my colleague to talk about why we brought the bill and some of the backstory behind it.
Senator Morrissey.
First of all, good evening, Mr. Chairman, good evening, members of the committee. This bill involves a dump in the city of Petersburg. I represent that city. There are 7 localities that bring their trash to that dump. That dump was purchased by CFS from the city of Petersburg in 2009. The Tri-Cities, Petersburg, Hopewell, and Colonial Heights, Chesterfield and Richmond, Dinwiddie and Prince George bring their refuge to this dump. Now, what occurred was this. There are limits to a dump as to how high you can go in the slope. For example, the higher you go, you have to be in compliance with DEQ regs as to how high and the slope. You don't want too steep of a slope. There was a consent order that was entered into in 2017, July of 2017, between DEQ and the dump. And in that dump, they agreed to do certain things. And then after that, DEQ inspected this dump. They inspected it at least 5 times. They inspected it in February of 2017, and they wrote, during the inspection, no apparent violations of your solid waste permit of the Virginia Solid Waste Management regulations were observed. They had another inspection on June 26th, exact same language, no violations. They had another inspection on November 29th, 2017, no violations. They had another inspection, December 22nd, no violations. Finally, they had an inspection on May 31st, 2018. Once again, the 5th consecutive no deficiency letter. Everything looks like it's going well. And then they came out, and after there was a rainstorm, and they noted some problems with the slope and the height. So they had a hearing, and that hearing was before a hearing officer. And that hearing could not have went very well for the owners of this landfill. They said, they looked at several different things, but they said the following. The most significant thing that they were focused on at this hearing where evidence was presented was the height and the slope. And here's what the hearing officer concluded. I conclude that although it was established that CFS, that's the dump, placed waste in a cell in excess of 35 feet higher than the permitted grades, CFS complied with the exterior slope requirements. It goes on to say, DEQ did not meet its burden of proof of that CFS violated the 2017 consent order. Then they looked at another one, and this dealt with the wattage drainage system. And the hearing officer concluded, I conclude that DEQ has failed to prove by a preponderance of the evidence that in July of 2018, CFS failed to maintain its surface water drainage system. And then, of course, all these dumps have methane gas. And they weighed in on that, and they said, at the end of the hearing, when evidence was presented, in this proceeding, DEQ did not meet its burden of persuasion that CFS violated the agency's regulations. Could not have gone too much better. But then when it was presented to DEQ, the director, ignored the hearing officer's recommendations in those 3 areas. And what did they do? They said, you're gonna close the dump down. And here's the problem. I represent Petersburg. I could be a hero if I just said, let's close the thing, and look what I did. That's the wrong thing to do. To close that dump means 35,000 tons. You gotta open up that top of the mountain. Imagine the odor that is gonna go through the Tri-Cities area, and then take 35,000 dump loads to Lunenburg or somewhere else. When CFS has already spent, remember they acquired it in 2009. They have spent $7 million preparing additional cells, preparing a transfer station. This dump, and that was the genesis of this bill. And Senator Reeves set forth earlier what the bill would do. I don't think I need to go into it again unless you want me to, but I've tried to give you a little history about it. And what you're gonna hear today are there's a representative, the mayor of Petersburg, and a city council member from Petersburg, somebody from Dinwiddie, someone from Prince George. They all want this dump to stay open. And CFS wants to maintain and do things right. Right? And the last thing I'll say is this. I have visited 4 dumps in my time. I've gone out to this dump 4 times. I have walked it in my boots. Gone to 4 other dumps. I can say with absolute certainty that this company is committed to doing it the right way, but this bill needs to be passed in order to allow them to proceed. There are some witnesses, including former Attorney General Troy and some members from the local cities that would like to comment.
The mayor would like to speak.
Yes, good evening, Mr. Chair, members of the House Subcommittee. I'm Sam Perrin, Mayor of the City of Petersburg, and I'm here to speak in support of this bill. The Tri-City landfill is very important to the City of Petersburg, and we have gone through a tremendous amount of financial stress in the previous years, and we have reached out to DEQ several times to meet with Director Paler about the landfill, and we've just been refused, and he's refused to meet with us and have a conversation on the impact that would have to the City of Petersburg, that CFS takes 100% of the trash from the city of Petersburg. And as Senator Morrissey said, the city was really blindsided because we have all of these reports of no findings of the landfill to all of a sudden we just there at closure without any type of a plan being explained to the city of Petersburg, and where are we going next and what the implications are going to be to the citizens of Petersburg. So again, I would like for you to support the bill, and thank you for letting me speak.
Anyone else? The former Attorney General?
Okay.
Go ahead.
Good afternoon, Mr. Chairman, members of the committee. I'm Marie Grant, and I'm here representing Dinwiddie County. Dinwiddie County values transparency and supports the premise that when a decision is rendered, the why is included. This is particularly important when said decision is rendered by a regulatory agency, as often there are widespread implications affecting our locality and its citizens. Closure of the Tri-City landfill has caused CFS Meridian Waste to reroute municipal waste trucks through Dinwiddie County to Lunenburg County, the most direct route being down US 460 right through our county, which poses 2 major concerns for Dinwiddie. First, the 460 Courthouse Road interchange is the most problematic intersection in the county and has been the site of numerous accidents and several fatalities. The design is poor, and additional traffic of this magnitude only increases the potential for problems. Rerouting these trucks is also more expensive for CFS Meridian Waste, and the additional expense will have to be passed on to their customers, i.e. the localities, which we will in turn have to pass on to our taxpayers, which is also a concern. When our Board of Supervisors renders a decision, sharing the rationale is standard practice, and we would hope that we could expect the same from regulatory agencies. We appreciate your time in allowing us to have a voice in this process.
Just a question for in the delegation. You said the cost would go up. Do you have an idea what the cost would be compared to what we have now? Is that
from the cost we've got is looking to triple the amount of
moving wages. Because right now, the city of Petersburg pays, $20 for 6 trash pickups. Means 4 regular trash and 2 recycles. And there's no way anyone can do it for, that cost.
So go from that to 60 or whatever. Okay, thank you.
Delegate, if I can add, when the city sold the dump in 2009 to CFS, there was a condition that you will not charge Petersburg residents and others the normal going rate. And Petersburg has been able to avail itself of that lower rate for the past 8 years.
Can we hear from the Attorney General?
Yes, from the former Attorney General.
Mr. Chairman, I'll be very brief. Let me emphasize what this bill does. It does not try to reverse the decision that was made by DEQ. What it does do is it says DEQ, when you're making a decision, number one, make sure you understand the impact on localities. Take that into consideration. Number two, if you're making a decision that is contrary to a recommendation of a hearing officer, let me digress a minute. These administrative hearings are brought in front of a hearing officer, which is an individual on the approved list by the Supreme Court of Virginia. They're trained to conduct these hearings. It's a full-blown hearing, and the importance of that hearing is when you go to court on that record. You do not, are not allowed to put additional evidence on the record in court. So you're making your whole case in front of the administrative hearing officer. What this bill says is to the DEQ, if you're going to make a decision contrary to the recommendation of a hearing officer, fine, but explain your rationale and the basis for making that decision. That's all it does. Yes, sir.
Delegate Waldo.
Mr. Troy, I guess, I think I heard you say that nothing in this bill affects this particular case, but I guess if I'm looking at enactment clause number 2,
yes,
then it certainly does.
Well, if the case is still pending, yes.
And it is.
Mr. Chairman.
Delegate Waldo.
So what is the timing on that case?
I apologize, I'm not sure. It's moving through the court system. It's been in front of the Circuit Court of the City of Richmond now for a while. I'm not sure when a hearing is set. I don't have that
From the mayor's
information.
office speak to that.
But what this second enactment clause says is, if this is to be the law, then make it applicable on any case that is pending, including this case.
Okay. Any other questions from the committee?
Thank you, Mr. Chairman.
Delegate Guy.
So the lawsuit's still pending, right?
Yes. Well, it's an administrative review or hearing.
Well, it's an appeal of
Yes.
the administrative hearing, so
Yes.
they still have, and I guess I'm supposed to address it to you. So, Mr. Chairman, so I'm concerned that I hate bills that try to fix lawsuits. And what this does is create a totally different administrative process across the board in DEQ, because we have a bad decision here, or what they think is a bad decision. I don't even know. I don't want to get into the facts of the case. And I have a real problem with doing that. Is there any other administrative process that this is mirroring, or?
Well, the question is if you wanted to expand it to all administrative hearings, but what this emphasizes is if you have an administrator of an agency that is going to reverse a recommendation of a hearing officer, then it's incumbent upon that person to simply explain why and the factual basis.
Well, when you appeal, when the claimant appeals to the courts, I assume the director has to explain. Would that be correct, Mr. Chairman?
No, you go on the record that was made below.
Attorney General. Say that again.
You go on a record that was made below. When you're in front of the court reviewing what the decision was below, it's on the record made below. You do not have the opportunity to put on more witnesses or more evidence.
I understand, but
Delegate Guy, any follow-up?
So when the claimant appeals the hearing officer's decision, which has apparently been overturned by the director, they go back to the original case, and the court has the right to review those findings of facts, which you now say the director has to enumerate. Is that correct?
Mr. Chairman, in essence, yes, here, there were no findings of facts enumerated or explaining why the recommendation of the hearing officer was ignored.
Were there findings of fact by the hearing officer?
Delegate Guy,
I'm sorry.
were there findings of fact by the hearing officer? Senator Morrissey?
Thank you, Mr. Chairman. Yes, and with regard to the most egregious alleged violation, height and slope, the hearing officer said, and I'm quoting, "I conclude that although it was established that CFS placed waste on cell D in excess of 35 feet higher than permitted grades, CFS complied with the exterior slopes requirement of the 2017 consent order." It went on to say DEQ did not meet its burden of proof that CFS violated the 2017 consent order. And they said that in 2 other areas. What was perplexing is that when that went to DEQ, those findings in 3 specific areas by the hearing officer were not given the due credit that they deserved. Nobody is asking anybody to reverse what the hearing officer concluded after listening to all the evidence.
Delegate Bullock?
Thank you, Mr. Chairman. And so I guess I'm always a bit hesitant to change law and process and procedure as a result of one particular case. And so that's what I'm trying to pay more attention to here, rather than focusing on the ins and outs of Petersburg. I do think it would be fair, I would like to put Director Paler on the spot. If you can go ahead and talk a little bit about it from DEQ's standpoint, because I worked with DEQ for a long time and have a hard time believing that this would be a staff decision without any kind of factual basis behind it. But if Director Paler could provide some perspective, I would appreciate it.
Director Paler?
Mr. Chair, Delegate Bulova, you want me to go through everything in response to all this now? Or just
Director Paler, if you could actually address a couple questions.
Yeah.
One is some of the allegations have been made about the specific process, but also about the bill itself, and whether or not, and if you could talk about some of the details of the bill and how that would change things, but also what your value proposition is, whether or not you think it's worthwhile.
Okay, yeah, I do agree, Mr. Chair, that the process is the principal issue here and not necessarily this case. If we got it wrong, the judge is going to say so. But this this bill would basically treat DEQ differently than from all other agencies. We have followed the Administrative Process Act through this whole process. We used escalating enforcement before we got to this process. We coordinated with our council all the way, and I think this creates a bad precedent from a policy standpoint, because it would treat DEQ differently than other agencies within the Administrative Process Act, and it would, by and large, hold, in this case, the DEQ director and the subsequent court judge to give primary deference to the findings of the hearing officer. So I think from a process standpoint, that's why we think it's a big mistake, and I certainly wouldn't think that it would make sense to do it just to DEQ if you disagree with one decision that has been made.
Director Paler, can you tell me what the term of art you used about escalating enforcement? How long did that take?
It's been going on for a little over 5 years. It was there were 2 consent orders. Whenever there are a set of violations that need to be resolved, we enter into a consent order. Consent order talks about what they need to do to get back in compliance, and may have a penalty. And we went through that process twice, and found that things that were agreed to in the consent order continued to not, the injunctive relief or injunctive requests of the consent order were not complied with.
Delegate Holland.
Mr. Chair, I would just ask the witness. So I'm disinclined, won't vote to legislate backwards what's already been done. I would want to amend it to apply it going forward. But I guess what I'm trying to understand is it does seem reasonable on a going forward basis to ask for a statement of fact when, and broadly across the administration, but you could start with DEQ. And so I'm just wondering why wouldn't we want to have this on a go forward basis?
Mr. Chair, Delegate Helmer, you should. And in our view, and in our attorney's view, the facts were presented that made the decision. And I guess I would also say, in response to a couple of assertions that have been made, during the time period of those consent orders, we had 51 inspections. 75% of them, including the most recent ones, had violations. The hearing officer, it's correct, did not agree with 2 of our findings, did agree with 4 of our findings, and those 4 were sufficient to make the decision that we made anyway. So I would take issue with some of the things that have been represented of our actions.
Delegate Helmer, follow up.
Just a quick follow-up. So I accept, I'm actually not interested, I mean, I'm not truly interested in the fact of this because I don't think we can litigate what has happened here. I am much more curious. I mean, as I read the bill, it says, when a hearing officer has made a recommendation to the department on a factual issue, a rebuttal presumption shall be created with respect to such facts. Essentially, that you'll put something on the record that says this is why we're acting in a manner inconsistent with what the hearing officer said. I don't think we should go backwards. I won't support this bill going backwards, but I wonder why going forwards we wouldn't want that sort of documentary evidence of why we act in a way different than what the hearing officer, who clearly has a much deeper understanding of the facts.
Mr. Chair, Delegate Helmer, I might suggest that would be a question to put to our counsel who is here. I simply understand that we have followed the Administrative Process Act, the process as it currently exists all the way forward. And while I don't disagree with what you're saying, I also don't think we have violated any of that. So if you want to get into process, I think that's absolutely the correct question. What's the right way to do this going forward? And from my standpoint, at least, I'm not sure that you would turn the Administrative Process Act on its head because of this one decision.
Delegate Simons?
Mr. Chairman, if the delegate would like to make an amendment, I would consider that a friendly amendment, and I agree. I mean, we're not asking that. If you look at lines 71 through 74, prior to revocation of a permit issued pursuant to this section, the director shall consider and issue findings of fact regarding the impact of revocation on the host community and on any locality relying on the facility for waste disposal as documented in regional solid waste management practice. So as Delegate Helmer said, it's fine. If you want to make it going forward, I'm fine with that. But this is one of those things where there's not real feedback back to the folks that had it happen. When you've gotten report after report after report, you're doing pretty good. Now, Mr. Chairman, I'll also say that there's a city councilman here who you all should have got a copy of the letter where they tried to reach out to DEQ, set up several meetings. DEQ never showed up, i.e. why we're here. So as elected representatives, we try to represent our businesses and constituents, and when you try to do that in front of a government organization and the door's constantly shut in front of you, that's not transparency, Mr. Chairman. So the delegate would like to make that change, or have council look at moving forward, not looking retrospectively. I'd be immediately with that.
Senator Reeves, Senator Director Baylor could speak to that again. He said that, the preceding hearing officer said that they found, they held up the DEQ position on 4 counts.
Yes, Mr. Chair, they upheld 4 of the 6.
And that was sufficient.
In our view, that was sufficient. That's correct. Maybe if I could make a comment, the mayor said that I wouldn't speak to him. That was on advice of council. Since I was the decision maker, it wasn't appropriate. But our deputy director, Jeff Steers, had a number of discussions with him. We had at least 2 meetings with local population down there. I have a hard time characterizing our actions as not transparent.
Senator Morrison.
Why we're on that point right now as to whether 2 or 3 or 4, it's very clear from the report that there were 4 things that the hearing officer said with absolute specificity that DEQ did not prove, and that involved slope, grade, and height, failure to maintain stormwater drains, methane exceedance. And I can read them to you again, but the hearing officer is clear in those 4 areas, not 3, not 2, but 4 areas that DEQ failed to prove its case.
Delegate Simons.
So I have a question, Mr. Chair. It seems like management of these dumps is a very important, sensitive environmental matter. And so the request that DEQ consult with localities and it seems like we would want the experts involved in evaluating these situations, and so I'm curious, these hearing officers, what expertise do they have in terms of evaluating a specialty thing like this waste management?
I think I can answer your question. That's a great question. And at the hearing, experts came in, and it was like a full-blown trial, and both sides put on experts. After they did that, the hearing officer then weighed in. I imagine I don't know what the expertise the hearing officer had in his own head, but experts did come in and provided evidence.
Delegate Simons.
Well, I do think that we want to make sure that the government has the expertise. Now, I understand that you all don't like the decision, and I would just say, even though I don't like this bill, I also am really concerned about opening up a landfill and trucking, 35,000, and that to me seems like a no-go. It doesn't seem like something we should be legislating, but is there another way that DEQ can work with the locality to solve this problem without us having to get involved? So I would ask Director Paler that question.
Director
Mr. Chair, Delegate Simons, we are in discussions with them, with CFS now about several options that would decrease the density of truck traffic and maybe the overall amount of truck traffic, because we do understand that has an impact on the community as well, as does operating a landfill in a manner that's not up to code either.
All right, Delegate Guy.
I just want to say again, this bill is not about that case. This bill is about paying the profit. And so I agree with Delegate Helmer that we want transparency. We want people to have to make findings of fact. And if you want to draft a bill for next session that would amend the Administrative Processes Act to make findings of fact routine across, that might be something we should discuss. But for us to pass a bill that says that deference is going to be given to a hearing officer who's picked, nobody's yet told us how, over a director who is selected by an elected governor and confirmed by an elected legislature, and the court shall give deference to such recommendations, is to me just insanity. And I can't support it as much as I have sympathy for the facts of the case.
So we've dealt with this for a while now. Can we give 5 minutes to folks who might want to speak in favor of the bill right now from the public? Anyone wishing to speak in favor of the bill?
Please, Mr. Chairman, thank you so much. Members of the committee, ladies and gentlemen. Alan Carmichael, I'm the Vice Chairman of Prince George County Board of Supervisors, going into my 13th year. We support the bill. It's very important for the localities to know what's going on right in your backyard when 37,000 individuals, we count on that landfill and waste disposal in Prince George County. Since CFS had come into the picture 6 years ago, it has brought their expertise in the trash business and took over the convenience station in Prince George County. And it all comes back to the citizens and the taxpayers. And it saved $1.3 million over 6 years in the taxpayer and then over the citizens. So we firmly support it. And And as this bill, should it be passed to go forward, I can assure you that if you bring Petersburg, Colonial Heights, and Dinwiddie, Hopewell, Prince George County to the table to let them know as these steps go on, what their local or locality of their transfer station, as it's going to use as of today, if there's any indications, and the young lady said about the transparency, you let these Board of Supervisors, City Council know that CFS is being looked at for certain reasons, and we know for the first day that they're having some issues, we will call immediate meeting with this vendor that we use, because it all comes back to the citizens and how much they're paying. And we would make sure that we stay on them more than probably DEQ could ever, because we know the impact it's going to have. And that's our take as far as Prince George is to support this, and thank y'all for your time.
Thank you. Mr. Attorney General.
Mr. Chairman, one clarification, if I may, and that is, as Senator Morrissey pointed out, the hearing officer, an appointed officer on the Supreme Court list, these are experts who know how to conduct hearings, take in evidence, found that there was no violation, or that the violations of slope and height had not been proven. The director reversed that without explanation, and that reversal said you have to now, without explanation, take 365,000 cubic yards and truck it away. Every dump truck is 10 cubic yards, so you can do the math. 365,000 cubic yards, that's 36,500 dump trucks of raw garbage going through the streets without an explanation from DEQ as to what was your basis of finding that. So that's the purpose of the bill. Thank you, Mr. Chairman.
Thank you, sir. Anyone else speaking in favor of the bill from the public?
Mr. Chairman, thank you for the courtesy. Rick Savage, representing Meridian Waste. A few facts, and this is not about Dave Pay, but Meridian is a very, very viable and they're environmentally conscious company. We purchased this facility in 2017. Many of the violations you heard about occurred long before we even bought the landfill. So I have issue with that. In addition, the first thing we did, and I think the lawyers will agree, is we entered into consent decree, an agreement. We gave our word, the state gave their word that they were going to honor it. And we did. We proceeded for about a year and a half to go forward with that promise. We pumped $8 million into this facility to try to make it right. We understood what we got when we bought it. It was not a facility, they said it was a facility with violation. But we, in good faith, we came to the table. We pumped a lot of capital into that facility. It's interesting that somebody has talked to me about a compromise or coming to the table. On no less than 6 occasions, the company has pretty much begged somebody to get around the table to resolve this in a reasonable manner. And as of yet, no one's contacted me or the company, as far as I'm concerned, about reaching a reasonable solution to this. It's an environmental disaster. Cracking that thing open, as you heard, is a disaster. Right. 36,500 dump trucks. That's about 130 miles, bumper to bumper. So somebody just needs, as far as a legitimate business from out of state that came here in good faith, did what we said we were going to do, to be treated like this, in my opinion, is just unheard of. So we asked for some relief from this committee, whether it's this bill, and contrary to Delegates Guy's suggestion that the bill has to go away till next year, it's always the purview of this committee to modify a bill and keep it going. And I think Senator Reeve had a few modifications. So, thank you.
Anyone speak? Can we just 5 minutes for a second?
Yes, I'm Councilman Myers, City of Petersburg. I'm sitting here trying to think of what I'm going to say, y'all. I support this bill. But when you think in terms of the decision from the director, it's creating more harm than good with respect to this, because now you're trucking waste across the city rather than maintaining it in the facility in which it is. And so,
thank you. We have 5 minutes for everyone in the public who'd like to speak in opposition to the bill. I feel like we've addressed a great deal of it. James River.
James River Association. So outside of the particular scenario, in this case with the landfill, I think our deep concern with changing the APA in this way with respect to DEQ is that it obscures the public accountability for these enforcement decisions. DEQ is charged with protecting our natural resources, and so it's important that the director retain that public accountability when these decisions are made. And we think that shifting that deference from the presiding officer, or from the director to the presiding officer, kind of cuts in the way way of the public really understanding who's responsible for these decisions. I think if you were looking for a way to change the APA, you want to look at it with all agencies in mind and not have a bill that's crafted really to look at this particular scenario. And you would allow, in this scenario, there is recourse for landfill. They are going through this appeal process, and that would play out. So thank you.
Thank you, ma'am. Sir?
Thank you. Paul Kugelman with the Virginia Attorney General's Office. I am the Chief of the Environmental Section, the Chair of the Administrative Process Act Committee, and the office's representative on the Administrative Law Advisory Committee of the Code Commission. So, with respect to the second enactment clause, as you pointed out, ma'am, it's unconstitutional because it violates the special laws provision of the Virginia Constitution. Basically, it takes a case in active litigation from a court, remands it back to the agency, and then instills another procedure that the agency needs to go through in a different way. Even if the second enactment clause is lifted, it would take care of the constitutional problem. But it's also the office's position that there's certain language that's left in the bill that would be problematic on court review. As General Troy had rightly pointed out, the case goes up to a court review on the record that's established before the agency. And you can't change it, you can't add to it, you can't take from it. The bill says that the court basically, on a factual issue, shall give a rebuttable presumption with respect to such facts, and the court shall give deference to such factual recommendations. Creating a rebuttable presumption on an appellate level flies in the face of basically well-constructed law. Rebuttable presumption is an evidentiary issue. It's applied to evidence. There's no evidence coming in. It's at the appellate level, so that language is problematic as well. And that's, unless there's any questions, that's all I have to say.
Delegate Holler?
Mr. Chair, I would just, a very quick question. So I just want to understand, practically speaking, from an Administrative Process Act, it sounds like when the director issues a finding, when the director finalizes it, right now there is no evidentiary standard that's that gets entered along with it that goes to appeal. Is that am I understanding that correct? Is that how we're describing it now? I'm probably not
Mr. Chair,
Sir.
I think this will probably better answer your question. The way the process works here is a hearing officer, I was at the hearing, the hearing officer hears all the evidence and it makes a recommendation to the director, Mr. Paler. Mr. Paler reviews that and he makes a case decision, a finding. The party complaining of agency action, here CFS, can take that up for court review. The court has to look at the record to determine, for factual issues, whether there's substantial evidence in the record to support the director's finding. And that's the way the process works currently.
Thank you, sir.
Yes, sir. Thank you.
Sir Globe?
We oppose.
All right. Anyone else in opposition? League of Conservation Voters. All right. Anyone else? All right.
Mr. Chair.
Delegate Gilbert.
Yeah, first of all, speaking to the bill, I'm struck that all the environmental folks are okay with the disaster of the environment being created by all these trucks moving around on the road, but I would inquire of council what we could do to striking the second enactment clause, and then what additionally would make this only forward-looking in its nature. I heard the Attorney General's office speak to that, but I don't know where the words are.
Chairman.
I don't see that in any of the italicized language.
My only thought on that would be the second enactment, and I would have to spend some time looking at to figure out Google's other point where that appears in the text.
Mr. Chair, I would move to strike the second enactment clause at this point. I think that resolves the
Motion.
that leads to that issue.
Second. Motion is seconded. All those in favor of striking the second enactment clause, say aye.
Aye.
All those opposed? Okay. So the new language is before us. Mr. Kugelman, can you speak to the question we have from the booth about
I believe
the
so,
other
sir.
problematic
Right.
languages?
And I apologize to Mr. Meacham for not pointing to the line numbers before. I'm looking at lines 10 to 17. So it says, in any form of proceeding initiated pursuant to 2.24020, where the parties are operating under a consent decree, the department shall give deference to the consent decree and findings of fact by a presiding officer based on the evidence presented at the hearing. Then it goes on to say, for any decision on review brought pursuant to 2.24027, in which the hearing officer has made a recommendation to the department on a factual issue, a rebuttable presumption shall be created with respect to such facts. That's problematic because it's only before the director at that point. There's nobody to argue one way or the other. There's no there's no presumption to be made. And then it goes on, and I don't know how to fix that piece.
Yeah, are you satisfied with just this first sentence?
Yeah.
Lines 16 and 17, and I don't mean any disrespect, I just don't know how to.
It's fine. Thank you, sir.
Yes, sir.
Mr. Chair.
Delegate Gilbert.
I think I'm gonna move to strike everything after the hearing on line 14 through line 17. Senator Morrissey, that was almost a motion. Hold on.
Right here. The decision, yeah, here, down 17 takes one of that section right, didn't it? Falls in the line.
So that's the problem.
Would you agree?
Still isn't. Scroll. Still isn't. Still isn't.
That's not gonna solve the problem anyway. You know, if we take out the second and after clause, and take out that sentence. It doesn't
Any
make
motion
sense.
there?
Nothing.
Yeah, I'm gonna move to strike lines, half of line 14 through 17.
Everything being in full.
Everything after
Yeah.
4,
Yeah.
including for any decision.
Fine for the future.
Yeah.
I still think it's in the wrong place.
Yeah.
I think we should just amend that.
So we have a
straighten
motion.
out.
Is there a second? Second. All those in favor, probably motion second, all those in favor, cutting, everything in half of 14 through the end of 17, beginning before any decision, say aye.
Aye.
All those opposed? Nay.
I'm fine with that,
It
but I'm
just
still
doesn't seem like this is right.
Do I need to be a chance again?
We have Mr. Delegate Bolivar.
I don't
know about that.
We do know where we are. We basically cut the second amendment, the second enactment clause, and we've cut the first the last 3 lines, 3.5 lines of 14 through 17. But we still have the problem lines 12 through 14.5 are still problematic.
So, Mr. Chairman, I don't want to cut off additional debate
Right.
or attempts to go ahead and work on this bill, but to the degree that we've gotten it to a point where we are now operating off of, just the first part, 11 through 14, I think we kind of know what it does. I still feel uncomfortable with respect to upending the process.
Right.
So, Mr. Chairman.
Yes, sir.
Assuming that that is the case, that we are done with debate, I would move to gently lay the bill on the table.
We have a motion to lay the bill on the table. Is there a second?
Second.
All right. All those in favor of laying the motion, I believe moved and seconded, to lay the bill gently on the table. All those in favor of laying the bill on the table, please vote on the electronic voting board. All right.
Thank you.
Thank you, Senator Reeves and Senator Morrison.
Thank you.
Senator McClellan.
Still didn't report.
Yeah.
Wouldn't have reported.
Senator McClellan, you have, Bill 1075. Yes, which is, really, just happened today.
I mean,
Wow.
Substitute, we have a motion to accept the substitute. We have a second. We have a second to accept the substitute.
Second.
Kind of liberal
All
stuff.
right, the substitute before us.
There's the camera there.
Senator McClellan.
Thank you, Mr. Chair. First, I'm going to tell you the problem I'm trying to solve with this bill, and it's taken several forms, but some forms which had a pretty large fiscal impact as a substitute before you hopefully get rid of the fiscal impact. This bill was originally brought to me at the request of a constituent who lives in eastern Henrico County and in Chesapeake County, where there are two gas power plants in the works. And they, by the time they found out about these power plants going through the approval process, there was a lot of confusion. They felt that there wasn't enough time to really have meaningful input before the air board, and they felt just very frustrated and shut out of the system. And so this bill was brought to try to figure out how can we improve an opportunity for communities that are going to be impacted, particularly by fossil fuel projects, to have their say. And so what the bill does now is that anytime the DEQ will promulgate any regulation or grant a variance to an existing regulation or a permit for a fossil fuel fired generating facility with a capacity of 500 megawatts or more, that if the board finds that there is a locality particularly affected by such regulation, a variance or permit, they will provide a little bit more notice as outlined in lines 32 to 43 of the bill. So they would, the air board would have to publish in a newspaper and at least one social media outlet in that area that would be affected at least 60 days prior to the close of any public comment period, outlines what would have to be in that notice, and then the applicant would have to mail that notice to the chief elected official, the chief administrative officer, the planning district commission, and then any public school or public libraries located within 5 miles of the facility, because in some facilities, just posting online may not be enough. Some people have to come to the school or the public library to access the internet. So that's the bill, and I believe at least one, if not more, of my constituents who requested the bill are here.
Any questions from the committee? Delegate Bolova.
So, questions for Senator McClellan or maybe Director Paler. So on line 15, when it talks about a notice approved by the board, I'm trying to understand the ramification of that, because if I understand the board meets quarterly, and so I'm not sure if it's that they have the capacity to be able to do that in a timely manner, and so I'm just curious whether that is essential to your bill or whether it mucks things up with respect to how DEQ and the board operates.
I'm sorry.
Senator McClellan.
Well, I was just going to say, my understanding, unless David Paler has a different one, was that most of the changes in lines 11 through 26 were more technical in nature, and the substance was later in the bill, but I think that's incorrect. I'm sure no one.
Mr. Chairman, very well, maybe you
Mr. Chair, Delegate Bova, in order for that not to create a delay, as you suggested, we would interpret that as a template approved by the board one time, and then, but we would not interpret that as the board having to approve every public notice.
Delegate Bolova.
Mr. Chairman, I guess I'm always reticent, and there's other bills too where if somebody has to make an interpretation, that means that we haven't written the language clearly enough.
I'm fine putting expressly saying that the board can delegate that responsibility to DEQ.
Mr. Chairman?
Delegate Bolova.
Can we just get rid of that language since they already have a process?
Just strike, approved by the board.
On page, on line 15. Senator McClellan, are you all right with that?
Yeah.
All right. Do we have a motion?
Well, Mr. Chairman?
Yes,
If I could, because I just have two other really quick questions. So the social media outlet, so I've never visited it, I'm sorry to say, does DEQ have like a Facebook page, and that's what we would anticipate would be your social media outlet?
Mr. Chair, Delegate Bolo, we have a Facebook page and Twitter right now, and we're in the process of expanding our social media presence.
And Mr. Chair, also in response to that,
Gen X.
so this does not necessarily have to be DEQs. It says that they would publish it on at least one. So let's say, they want it published on the RTVs, let's say it's in the Metro Richmond area, and they want that notice published, through the RTV's Facebook page, or if there's like a local blog. It doesn't necessarily have to be DEQ, but they would choose a social media outlet that they think would be appropriate for that area.
Delegate Helmer?
Mr. Chair, I think this is probably a question for council, which is just this social media outlet. When you say blog, I got really worried for a second. I'm thinking like, can DEQ, does a social media outlet have a widely accepted understanding within the context of the code itself?
Mr. Chairman, I believe the code already uses that phrase, social media outlet. So my answer would be yes.
Okay.
Mr. Chairman?
Delegate Bolo?
And I guess going to line 40, because I know you've tightened this up, so it's planning districts and chief administrative officers. And I think public libraries makes a good deal of sense, because that's where people generally gather, and you're right, people use computers, you can do public notices there. I don't know that that's necessarily the same thing with public schools, so a regular person can't just walk into a public school and get a public notice like that.
Do you have a question, Delegate Bolo?
Well, I guess my question for Senator McClellan is how wedded is she to that? Because I think public schools are gonna get that notice, and it's gonna go into the recycling.
If you prefer public schools to be taken out, I'm fine as long as we leave public library. I mean, the point here really is, what's the best way to disseminate this to the public? And so I would agree that as long as the library and the elected official and the chief administrative officer have it, but I think we wanna make sure at least somebody other than the government officials have it.
Totally agree. So, Mr. Chairman, I would make a motion that we strike approved by the board in line 15, that we strike, public schools on line 40.
And to all public schools.
So it would be for each locality affected and public libraries located within a 5-mile radius. And then, I would be a very bad House member indeed if we did not strike the clause on
44
lines
to
46.
I expect that.
All right.
How about schools? With
Delegate
regard
Guy.
to public schools, you're correct that the notice would not then be promulgated to the public at large, but it would go out inside the school community. You don't think so? I mean, in my experience, PTAs are like rabid about it, impacts and things that might impact their kids, but okay.
Delegate Helmer.
I'm not wedded to it, but I don't think there's any harm.
Mr. Chair, to that very fine motion that the delegate just offered, that there is one, I think it would be useful to specify that the social media outlet, at least that one has to be the one that the department uses for its general communications. I would want that. I just don't want it to be funny business type, did it on the blog or whatever. So at least one at least the social media outlet of
A notice on the DEQ's chosen social media outlet and one additional social media outlet. Otherwise, Mr. Meacham?
That's fine, Mr. Chairman, and I checked the code and we would use account rather than outlet. I was
Right.
mistaken.
Count. Okay.
So at least the department.
And so the notice on the DEQ's social media account and at least one additional social media account. So we have a motion before us to make those edits.
Second.
Motion moved and seconded. All those in favor say aye.
Aye.
All right, we have the bill with amended proper posture ahead of us. Do we have anyone who'd like to speak in favor of the bill? Ma'am?
Thank you. My name is Barb Adams. Thanks to the chair and to the committee members.
We've been 5 minutes in the board.
behalf of citizens of Charles City County, that Senator McClellan mentioned earlier. I was asked to speak today because of their concern, because they are facing two massive gas-fired plants that they knew nothing about. I would say that the guidelines that exist were not adequate for them. As a majority minority community and lower income and rural population, theirs is a community that would be disproportionately and adversely affected by these projects compared to other communities in Virginia. First and foremost, Senator McClellan's bill would ensure that people living in such communities would be effectively notified for them about such projects, something that did not happen for residents of Charles City County. I will speak to your comment. I know that amendment has been made, but folks in Charles City County, it's very rural. 80 people go to the library. That's why we mentioned libraries, but schools are hubs. They're center and they are a public venue. So that is why schools were included. For a community with not much access to a lot of social gathering places, schools and churches do that. But we included schools in that because it would access at least parents and those with the children that are there. So I just wanted to clarify where that came from and our concern there. So the existing notification and guidelines were not adequate for those people, and I would say not for many people in rural and challenged communities.
Thank you, ma'am. Oh, sorry.
Just a little bit, I'll be fast.
Sorry.
Allows clear access for the, especially for people in rural communities to access the process that the DEQ and the Water Board and Air Board enact. And it also ensures adequate time for citizens who may not understand the technicalities of these polluting projects to really engage in them. It helps address the real imbalance between polluting industries and the people who are most affected by them. So thanks for supporting this bill and your consideration.
Thank you, ma'am.
Mr. Chairman, members of the committee, Peggy Sander, Chesapeake Bay Foundation. I want to thank Senator McClellan for bringing this bill, which we consider very thoughtful, and it will be a benefit to the communities that are affected.
Thank you, ma'am. Sir.
Gustavo Angelos from the Sierra Club. We're in support of the bill.
Sir.
Steve Fishback from the Virginia Poverty Law Center. This is a very good first step to increase public notification and public participation, and we look forward to working with DEQ and other stakeholders to make further improvements in the years ahead.
Thank you.
We support the bill.
Ma'am.
Kendall Crawford, Virginia Interfaith Power and Light. We also want to thank Senator McClellan for her work on this bill, and we support it because it would make it easier for our neighbors to engage in the process of being good stewards of creation. Thank you.
Thank you, ma'am. Anyone speak in opposition to the bill? All right. Delegate Volvo.
That we report as amended.
Second.
All right, we have a bill to, moved and seconded properly, to report as amended, or as a substitute. All those in favor, please vote on the electronic voting board.
Mostly because Kelly wouldn't stick with me.
All right, thank you, Senator McClellan,
Thank
7-0.
you all very much.
All right, our last bill of the day, Senator Lewis. Senator Lewis, you have, 7776.
Yes, sir, Chairman, 776. Mr. Chairman, I think there are some friendly line amendments.
Mr. Meacham.
Mr. Chairman, on line 39, after the word management, the amendment would strike the remainder of line 39 after the word where on line 40, and it would insert the word unless. The second of four amendments is on line 40, after the word are, A-R-E, it would strike the word suitable and insert not feasible. The third amendment on line 41, after the word not, would strike the word suitable and insert feasible. And the final amendment on line 170, after the word is,
Oh, hold on. We have to go fast. 170?
that's right, line 170 on page 3, after the word is, would strike the word suitable and insert not feasible.
Thank you. Okay, could you repeat the first amendment again?
Certainly. I'll go a little slower, Mr. Chairman. On line 39, after the word management, near the end of the line, it would strike the rest of that line, and it would continue striking through the word where on line 40. place of those stricken words, it would insert the word unless.
Thank you.
Mr. Chairman.
Mr. Bullock.
Hate to provide extra work for Mr. Meacham, but I think the issue was making sure that it read a little clearer in plain English what we were trying to do. And so can you read the new sentence?
Certainly. On line 39, it would begin, letter D, the commission shall permit only living shoreline approaches to shoreline management unless the best available science shows that such approaches are not feasible. If the best available science shows that a living shoreline approach is not feasible, the commission shall require the applicant to incorporate to the maximum extent possible elements of living shoreline approaches into permitted project.
All right. I think we'd like to add another amendment as well.
Okay.
On line 301 to 303, we can remove the clause. Is there an amendment along those lines?
So can I do both those amendments at the same time?
You could.
I would do so.
Is there a second?
Second.
All those in favor of these amendments from Mr. Meacham, say aye.
Aye.
Aye. All right. So we have a bill properly before us. Senator Lewis.
Mr. Chairman, members of the subcommittee, as the subcommittee may recall, several years ago, we elevated living shorelines as a preferred management, for shoreline management, preferred tool for shoreline management. And what this bill does is solidify and strengthen that commitment to living shorelines for shoreline management. And as you gleaned by going through the amendment process, the guts of the bill simply states that the commission shall not allow any other shoreline management process if living shorelines are feasible. And so feasible, I think, is a key word here. And then it goes on to state that even if they're not feasible, if any element of living shorelines can be incorporated in the shoreline management project, that some elements are to be incorporated, again, if feasible. And so that's what the bill does, Mr. Chairman.
And this is also an agency bill, correct?
It is, yes, sir.
Thank you. Delegate Holler.
Mr. Chair, just it's more of a comment than a question. Just I know Fairfax County has adopted this policy for extended do. It's been very successful, so we're excited to see it.
Thank you.
Mr. Chairman.
Delegate Ransone.
So I have a question for the senator. Best available science. So where we live, and probably where you all are too on Eastern Shore, and you're facing a nor'easter or a tropical storm or a hurricane, particularly just the nor'easters and the bad storms that are coming in. And sometimes you're creating buffers, and you know as well as I do, a living shoreline is not always gonna work. You have to have hard stone. So if you go into BMRC for approval, are they going to reject you, Mr. Chairman, to the patron of the bill? What happens in that scenario? Are they gonna send you back and say, I need proof that you've come up with the best available science?
Well, I think,
Senator Lewis.
Mr. Chairman, Delegate Ranson, I think that the idea is that they'll do this in concert with BIMS and that they'll work on a series of criteria to establish when and where they're going to, under what situations. Clearly, there are going to be situations where the energy is such that, as you correctly said, the living shoreline is not going to do the trick. And so we're kind of dependent upon them to do that.
Okay. Follow up.
Better than feasible.
Delegate Guy.
I'm sorry.
Aye. All right. Any other questions from the subcommittee? Anyone from the community wanting to speak in favor of the bill?
Mr. Chairman, my name is Ellen Boland. I'm the Deputy Commissioner of the Marine Resources Commission. Again, this is an administration bill. Really thank Senator Lewis for his leadership and for Delegate Boland for adding to the bill today. We support the bill.
Thank you.
Nick Robner
Hold on
with the
for a
Nature
second.
Conservancy,
Delegate
and we
Bolaxon.
support the bill.
Just a quick question for VMRC. So when you're talking about feasibility, but there's nowhere in this that talks about cost. I'm concerned that cost won't matter if you can do it any other way.
Mr. Chairman, Delegate Bolaxon, that is correct. Our focus is on the feasibility and the logistics of the scenario.
Sorry. Ms. Robner?
I'm Nikki Robner with the Nature Conservancy, and we support the bill.
Thank you. Sorry. Thank you.
Jay Ford, Chesapeake Bay Foundation, we support.
Thank you.
Grace McGuire, Virginia Conservation, we support the bill.
Thank you.
Brian Hunsker and Friends of the Rappahannock, we support this bill.
Thank you.
Pat Coward, Virginia Conservation Network,
Mary Garson Smith, Wetlands Watch, we work statewide to protect wetlands
All right, anyone speaking in opposition to the bill? All right, committee works by motion.
Move to report. Second.
All right, the bill is moved and seconded with amendments. All those in favor, please vote on the electronic voting board.
Oh, my apologies. Who changed it?
By a vote of 5-2, the bill reports.
All right, Mr. Chairman.
Thanks, Senator
Thank you,
Lewis.
committee.
And with that,